finds difficulty, it should be lucid, clear, and as to how the facts, law, and the rules have to be culled out. These are the various aspects which have to be considered. And similarly, while you prepare your defense or a written statement, what are the defenses and in what manner and in what way it has to be projected? And as to what facets one has to take into consideration as to whether the pleadings will be as it is what we do in the civil side on the arbitration, or there are various, as I say, wheels within wheels. What is the variation in that? Keeping in view the consideration that when Justice N. Kumar, a former judge of Karnataka High Court and a former director of Karnataka Judicial Academy, we requested him, keeping in view the previous session wherein, what we can say, in a typical English manner, it all went gaga. The Facebook was fully exploding with the views. The YouTube was fully exploding with the views. So we thought, once this topic is such where it actually requires the finer nuances to be understood, we requested Justice N. Kumar, and as we all know that he took a series along with the Karnataka Bar Council, and he was kind enough to share the knowledge. We said that with this, his knowledge sharing platform, by being a resource person, pan India professionals, students of law, judicial officers would be actually enriched by that. And as usual, he agreed upon that. And in this way, we are connected with him on this platform. And on behalf of all those who are watching us live on the Facebook, YouTube, and on this platform, we welcome you, sir. And we are actually glad that you have agreed, despite being over busy with the arbitration acts and other platforms where you share your knowledge, that you acceded to share your knowledge on our humble platform. Over to you, sir.
Thank you. Good afternoon. The pleadings, as we lawyers and judges understand, is the foundation of a litigation. When we say pleadings, in the recent days, I find it has been equated to whatever you put in writing and file it before the court. Whether it is the courts or in the arbitration proceedings. I am of the opinion it's high time the legal fraternity should have a clear notion about what the pleadings is. The reason is, I find today lawyers are all 5-year law students coming from very good background. Their knowledge of English language is very good. With all this, when it comes to pleadings, it is not your command over the English language, the language you have studied by reading Shakespearean dramas, which really count in a court of law. The word plead, if you properly analyze it, you are before a court, pleading, requesting the court to grant you a particular relief. If you really want a relief from the court, what should be your approach? You should be able to say what you want to say in simple words so that the judge understands what your problem is, what your grievance is, and in law you are entitled to that benefit. You must get it immediately, is it not? At the same time, the other side also should know what your grievance is. But if you go on saying what you want to say with all unnecessary things, make it very big. Take it from me, no judge will have the patience to read all that. Many times he will struggle to find out what the case is. What is the injustice done? What is that he can do? Therefore, this word pleadings, you need not go to the dictionary meaning, because the word pleadings is now defined in the Civil Procedure Code. Civil Procedure Code is the procedural law of the land. Whether it is a court of law, whether it is an arbitration proceedings, whether it is a writ petition in the High Court, whether it is a election petition, company petition, take any civil matter for that matter, CPC is made applicable, if not in full terms, substantially. And therefore, the pleadings today in India is governed by the rules stipulated in the Civil Procedure Code. The Civil Procedure Code says pleading means plaint or written statement. It ends there. Please bear in mind, plaint, where the party has approached the court, will plead his case. And the written statement, the opposite party against whom the complaint is made, puts forth this case. These are all the pleadings. Now, when we talk about pleadings, it is not something you plead first and then think about the case as and when the case progresses. Your pleading should contain your case, the relief you want, and the facts leading to that relief. Therefore, before you draft pleadings, the person who has come to court should know what his right is. What is that right which has been infringed? And what is the relief to which he is entitled to in law? So he must have a clear notion before he starts pleading, drafting pleading. And if the right is already denied before he came to court, then he must be thinking of establishing his case by producing evidence. Evidence means moral evidence, documentary evidence, and presumptions of law. So all this exercise must be undertaken before drafting a pleading. That apart, we have section 9 of the Civil Procedure Code, which says civil court will have jurisdiction to try all suits of civil nature unless the jurisdiction of the civil court is expressly or by necessary implication barred. So that is another aspect which a draftsman should keep in mind. Then he should also keep in mind what is known as jurisdiction of the court. The jurisdiction of the court may be pecuniary jurisdiction and territorial jurisdiction. Insofar as pecuniary jurisdiction is concerned, for the purpose of court fee and for the purpose of jurisdiction. So all these aspects should be kept in mind before you start drafting it. Then there is another concept, that is, when you are coming to court and when you are framing a suit, you may be entitled to more than one relief on the set of facts. Therefore, the suit to be drafted, plaint to be drafted, shall as far as practicable be framed so as to afford ground for final decision upon the subjects in dispute and prevent further litigation concerning them. Therefore, it can't be in installments. And then another rule to be kept in mind while drafting the plaint is when you are entitled to more than one relief, your claim should include the whole claim. The rule in this is embodied in Order 2, Rule 2 CPC. It says, every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action, but a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. So therefore, an option is given to the plaintiff. If you are entitled to more than one relief, if you want to give up one relief, by all means you can give up the relief. But once you give up the relief, then you will not be entitled to put forth that claim in a subsequent suit. Further, it also says, if there is an omission to frame a rule, or sometimes it so happens it is not necessary to seek for all the relief, then in such circumstances, what the law expects is you have to seek the leave of the court to approach the court again on that relief which you are not claiming it, and then you can seek for the relief which you immediately want. In fact, in this regard, section 34 of the Specific Relief Act also has to be kept in mind. There it says you have come to court seeking a declaratory decree, and when you seek a declaratory decree, if you are entitled to any further relief, then only that relief becomes meaningful. And if you don't seek that further relief, then no court shall make any such declaration where the plaintiff being able to seek further relief than a mere declaration of title omits to do so. So these are all the aspects which a lawyer should keep in mind when he seeks to draft a plaint, when he seeks to draft a writ petition, when it is to draft a arbitration petition. Now, once all these things are kept in mind, now the law of pleading as embodied in the Civil Procedure Code has to be kept in mind. As I said earlier, Order 6 Rule 1 of the Civil Procedure Code states, pleading shall mean plaint or written statement. Plaint or written statement. Having made it clear, then the law says what this pleading should contain. What this pleading should contain. It says every pleading shall contain, uncontained, contain, uncontained, only a statement in a concise form of the material facts. A statement in a concise form of the material facts on which the party pleading relies on for his claim or defense as the case may be. And more importantly, it says, but not the evidence by which they are to be proved. Not the evidence by which they are to be proved. Therefore, when we are talking about pleading, the pleading should contain, uncontained, only a statement in a concise form of the material facts, not all the facts, material facts. And under no circumstances, it should contain evidence which the party has to prove, has to lead in support of the plea. Of course, Civil Procedure Code also says you have to do it in a paragraph, words, numbers, that's all. There's no difficulty about that. But what is important is the pleading should not contain evidence, and the pleading should contain material facts, and it should be stated in a concise form. The reason being is the object and purpose of pleading is to enable the adverse party to know the case it has to be. If the whole object is to confuse the court and the judge, this principle will not apply. Most of the cases, that is what is done. If you have a good case, you must get relief. If you want relief, you must be straightforward, put it in a precise manner so that the court understands. But if you are not sure about the case, we have seen pages and pages are written. The other side also will not know what you are saying. Court will also not. Maybe if you are using the judicial process for some other purpose, that's a different thing. But a genuine claim, if it has to succeed in a court of law, statement in that plaint should contain only the material facts in a concise form and not the evidence. Same object. Other side should know what your case is so that he can effectively meet. Assuming what you are saying is true, he may accept it. Where you are saying is not acceptable, then they will deny it and put forth their plea. Therefore, the pleading assumes importance. The general rule as far as pleading is well settled is that the relief the party wants the court to give should be founded on the pleadings made by the parties. Nobody should be taken by surprise. Opposite party should not be taken by this. You say what you want to say, you will have an opportunity to have it say, and then the relief you are seeking from the court should be founded on the pleadings. Now, it is also equally well settled. Without a proper plea, even if you adduce voluminous evidence, it has no value. The evidence to be adduced is to prove the plea. Without plea, you adduce evidence, it is of no use. Similarly, you make out a very good plea, but there is no evidence adduced. That plea is also no use. So, plea without evidence and evidence without plea is of no assistance in resolving the dispute between the parties. Secondly, another important thing is why when the law says pleading should mean plain and written statement, you cannot plead something and travel beyond the pleading because it offends principles of natural justice. So therefore, it is also not permissible. And keeping in mind these well-settled legal principles, if you have to draft a plain, then you can call it as an art. Merely because you know English, merely because you know facts, that by itself will not enable you to bring out a good plain or a written statement. You must have a sound knowledge of substantive law. You must know these principles which govern the pleading, and then only you can draft a good plain, which is the foundation of your claim, and you can develop that plea by adducing evidence and secure the relief to which you are entitled to in law. Today, what has happened? Today, the pleading in any case runs to pages, 10 pages, 15 pages, 20 pages. Is it really necessary? Probably there is a feeling among the lawyers, if the pleading is short, judge may think you have no case, or the party may think that the lawyer has not done his job properly. Drafting of a plain is purely a professional job. It is professional job. It is an art that cannot be decided by the number of pages. So therefore, lawyers should have the courage to withstand these pressures from any angle and stick to their professional standards and stick to what the CPC says, and then help the court in assisting the administration of justice. In fact, Civil Procedure Code Order 6-3 to assist the lawyers has given form of pleadings in Appendix A. You have a look at that. See the length of that pleadings. Maybe that is too short. You can improve it upon, but it can't be running to pages and pages so that the very object of the pleading is frustrated. In fact, what I am saying today finds favor today by the recent amendment to the Civil Procedure Code. In 2015, the Commercial Courts Act is enacted. And in the Commercial Courts Act, the major portion of the act is an amendment to the Civil Procedure Code. And the jurisdiction of a Commercial Courts Act originally thought was about 1 crore. And now for that, special rules are now added in the Civil Procedure Code. If you look into those amendments, then you will see if a suit of that higher value, the law says the pleading should be in this fashion. In my view, the same rule should apply to ordinary suits and more so the proceedings before the arbitrators, because most of the matters before the arbitrators are matters which should be before the commercial courts. There the claim is huge. And therefore, if you look into the way in which the law is being amended, you will get an idea. You will get an idea where we have gone wrong and now an attempt is made to correct it. Now, when we talk about material particulars, the Civil Procedure Code also says in what cases the particulars have to be given, which is necessary. It says in all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary beyond such as are exemplified in the forms aforesaid, particulars with dates and items, if necessary, shall be stated in the pleading. Therefore, though as a rule, it should be a concise statement only giving material particulars, insofar as these instances are concerned, better particulars have to be furnished so that the other side knows the case and able to meet your case. Here, let me point out one factor which has crept into our legal system. Today, you file a claim, there is a written statement. After written statement, the law do not provide for any reply, rejoinder. Today, especially in the arbitration cases, while fixing the time schedule, a date is given for filing replies and rejoinders. Now the question is, what is the use of that? If the defendant has said certain things or made allegations in the claim, it is for him to prove. It is not necessary for the plaintiff, the petitioner, to deny those allegations. All that happens when a reply is given is those allegations are denied. And then a rejoinder is filed. Now the question is whether the facts pleaded in the rejoinder or the reply, could it be taken as a pleading and on that basis the court can decide it? Certainly not. Sometimes it so happens, you have pleaded a particular case, opposite side has effectively met that case, so you want to deviate. The deviation cannot be done in the reply or rejoinder because that is not a part of the pleading. Then what is the option to you? What gives you an option? Assuming that you have pleaded something which has been effectively met by the other side, and you have another angle to that particular case, which may be inconsistent with what you have already pleaded, law provides for it. Order 6, Rule 8 of the CPG specifically says, where a contract is alleged in any pleading, a bare denial of the same by the opposite party shall be construed as a denial in fact of the express contract alleged or the matters of fact from which the same may be implied, and not as a denial of the legality or sufficiency of such contracts. But if you want to take a different approach, law provides for it. That is, Order 6 Rule 7 says, no pleading shall, except by way of amendment, raise any new ground of claim or contain any allegation of fact inconsistent with the previous pleadings of the party pleading the same. If you want to depart from the case which you have pleaded, That you cannot do by way of reply. That you cannot do by rejoinder. You have to do it by way of an amendment alone, departure, or pleading something inconsistent with what you have already pleaded. The law provides for it. Once the plea is amended, plaint is amended, or return statement is amended, then the other side will get an opportunity, and what you say in turn would be the real pleading and not otherwise. So therefore, we are going to go back to this. In the rejoinder, reply running to pages and pages, especially in arbitration case, new cases are pleaded. And what does the Arbitration Act says? Arbitration Act is supposed to be simpler than the CPC. And it says, Section 23 speaks about statement of claim and defense. It says, within a period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state the facts supporting his claim, the points at issue, and the relief or remedy sought, and the respondent shall state his defense in respect of these particulars, unless the parties have otherwise agreed as to the required elements of those statements. So these are
sorry to bother. Just check for a minute. There's a lot of disturbance. Maybe it's on your back or your speaker has just started creating some disturbance.
Srinivas. Now is it all right?
Yes, sir.
So therefore, personally, I feel anything which you have filed after the written statement by way of reply or rejoinder cannot be construed as pleadings. In fact, Order 8 Rule 9 specifically says, if you want to file some statement, take the permission of the court and file an additional statement, but not rejoinder. Or so neither Section 23 of the Arbitration Act nor Order 6, 7, and 8 of the Civil Procedure Code provides for these rejoinders and replies. Now, once the pleadings satisfy the requirement of these provisions, then the question would be of if an amendment is required, what is that you have to do? Order 6, Rule 17 of the Civil Procedure Code provides for amendment of the pleadings. Earlier, an application amendment could have been filed at any stage of the proceedings, including appeal and second appeal. Now that has been amended. Any amendment before commencement of the trial is allowed as a rule. But if an amendment is to be filed after the commencement of the trial, leave of the court is required and you have to make out a case for such application. Sometimes we find in the reply and rejoinder I was referring to, you are finding fault with what the defendant has said in the statement. If you want something there is to be struck out, as it is not depicting the true facts, or it is scandalous or frivolous, Civil Procedure Code provides for striking out pleadings. Of course, before you seek the pleadings of the opposite party struck down, you have to make out a strong case. Otherwise, the courts will not invoke that provision and strike out the pleadings. So therefore, Order 6 Civil Procedure Code, read as a whole, clearly makes out what a pleading, especially the plaint, should contain. When you read that with Order 7, which speaks about a plaint, it speaks about what are the particulars to be contained in the plaint. It is making it very clear. Before you draft a plaint, you must have the knowledge of substantive law. You must have the knowledge of the limitations of a pleading and what are the particulars which are to be mentioned in the plaint. Now, after the pleading is filed, the law gives an opportunity to the opposite party to file the written statement. Now, this written statement, hitherto, especially in trial courts, contain two portions. The first portion is denial of the entire case of the plaintiff. Let him prove it. That's the attitude. Then they will say what their case is. So the written statement will be double the size of the plaintiff. In the first stage, you deny the whole pleadings. In the other stage, you are setting out your case. Perfectly all right. But the question now is that pleading consistent with what is contained in Order 8? Because Order 8 specifically says how a written statement should be. It says, Order 8, Rule 2, the defendant must raise by his pleadings all matters which show the suit not maintainable, and the transaction is either void or voidable in point of law, and all such grounds of defense as if not raised would be likely to take the opposite party by surprise, or would raise issues of fact not arising out of the plaintiff, as for instance, fraud, limitation, release, payment, or performance, or fact showing illegality. Therefore, mere denying the plaintiff allegation is not really sense a written statement. You have to set out what your case is. Denial is all right. You have a defense, and that defense also should be meticulously set out with clear particulars, and that also should be in accordance with law. Now, what the written statement the law expects is, if you are denying it, mere denial is not sufficient. If it's a mere denial, what is the effect of it? Order 8, Rule 3 specifically says, it shall not be sufficient for a defendant in the written statement to deny generally the grounds alleged by the plaintiff. That is not sufficient, but the defendant must deal with specifically with each allegation of fact of which it does not admit the truth except the damages. But we find in the written statement, the allegations in para 2 of the plaint repeat the whole plaint, then say denied as false. Plaintiff is put to strict quote the same. That is no denial at all. That's what it says. But unfortunately, we find the denial. Now, as this is the way it was denied, and it was causing a lot of delay in disposal of cases. Now, in the Commercial Courts Act, by Act number 4 of 2006, the CPC is amended only for purpose of commercial courts. We should not confuse. Now, the CPC has got two purposes. For Commercial Courts Act 2015, amendment is applicable in addition to the remaining sections. If it is not a commercial court, this amendment is not applicable. Now we are in an era of commercial cases. Arbitration cases are also our commercial cases. Now you see what the legislature has done. Therefore, hereafterwards, advocates must be very, very careful in drafting a written statement. A mere denial and your statement is not correct. Please see what the legislature has done now, Parliament has done. They have introduced 3 capital A. Denial by the defendant in suits before the commercial division of the High Court or the commercial court. Now they say how the denial should be. Denial should be in the manner provided in sub-rules 2, 3, 4, and 5 of this rule. How? The defendant in the written statement shall state which of the allegations in the particulars of the plaint he denies, which allegation is unable to admit or deny, but which it requires the plaintiff to prove, and which allegation he admits. So mere blanket denial is no denial now insofar as commercial courts are concerned. You must say what allegations you deny, what allegations you are unable to admit, what allegations you want the plaintiff to prove, and what allegations he admits. So it is divided into 4 parts. Thereafter it says, where the defendant denies an allegation of fact in a plaint, he must state his reasons for doing so. So mere denial is not denial. You must give reasons. And if he intends to put forward a different version of events from that given to the plaintiff, he must state his own version. Now, therefore, you cannot have 2 portions of the written statement. If you are denying a particular allegation, if you are denying an allegation in a particular para, by all means you deny it, but you must also give reasons why you are denying it. And then if you have your own version, it must come and there itself. Therefore, when we read a particular paragraph in the plight and then read the written statement, the courts must get a clear picture of what is admitted, what is denied, what is the reason for denial, and if there is a different version, what is that version. Then earlier we used to say, the suit is not maintainable, this court has no jurisdiction. Now that is over. Now it says, if the defendant disputes the jurisdiction of the court, he must state the reasons for doing so, and if he is able to give his own statement as to which court ought to have jurisdiction. If you say this court has no jurisdiction, fine. You must be able to say which is the other court which has jurisdiction. Earlier was, it is for the party to decide in which court he has to file it. The court can only say, I have no jurisdiction. But now the law is saying, if the defendant says that this court has no jurisdiction, he must give reasons, and then he must also say, if this court has no jurisdiction, which is the court which has got jurisdiction. Similarly, regarding valuation, you are not admitting the valuation and you are denying it, you must also give your valuation of the suit. So today, drafting a written statement, especially in the case of a commercial cases, a mere denial is not sufficient. Before you deny, you should think. You must give reasons for denial. If you have your own version, you must give that version so that the court will be able to appreciate the material fact alleged in the plight and your denial in a proper perspective. Now, we saw about specific denial. If the specific denial is not there, it is no denial. Then Rule 4 talks about what is called as evasive denial, where a defendant denies an allegation of fact in the plight, he must not do so evasively, but answer the point of substance. Thus, if it is alleged that he received a certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he received that sum or any part thereof, or else set out how much he received. And if an allegation is made with diverse circumstances, it shall not be sufficient to deny it along with their circumstances. Though this particular provision is there in the Civil Procedure Code from 1908, unfortunately, this has not been properly given effect to. If properly it is given effect to, the time taken for trial would get reduced. Then it also speaks about what is known as specific denial. Every allegation of fact in the plight, if not denied specifically or by necessary implication, or stated to be not admitted in the pleading of the defendant, shall be taken to be admitted except as against a person under disability. In fact, a second provision is added to this. This is the most dangerous provision now. A lawyer should be careful. In the earlier paragraph, he said, if you are denying it, you must give reasons. If you have a version of yours, you have to give it. And if you don't do it, what are the consequences? It is said so. Every allegation of fact in the plight, if not denied in the manner provided under Rule 3A of this order, shall be taken to be admitted except against a person under disability. So your written statement is of no use if the written statement is not in accordance with the aforesaid law. The court today is empowered to take it as an admission and grant a decree as prayed for. So therefore, that shows the importance of the pleading. It is not mere writing. It is not mere denying. It is not mere English. The person who drafts either the plight or the written statement should bear in mind the rules of the game and see that his client's interest is properly protected and by his lacks, the interest of the party is not affected. Now, when we are talking about written statement, it has got certain special rules. One such rule is you can set up a plea of set-off. You can also put forth a counterclaim. So therefore, it is not mere denial, acceptance, admission. There are cases where when the plaintiff is putting forth a claim for money, though the defendant is due, plaintiff also may be due in certain amounts to the defendant. Now the question is he expected to go and file another suit to recover that money? In such circumstances, the law provides for what is known as set off. You can set off the claim of the plaintiff as against the amount due from the plaintiff to you. It says, where in a suit for recovery of money, the defendant claims to set off against the plaintiff's demand any ascertained sum of money legally recoverable by him from the plaintiff, not exceeding the pecuniary limits of the judge of the court, and both parties feel the same character as they feel in the plaintiff's suit, the defendant may, at the first hearing of the suit, but not afterwards, unless permitted by the court, present a written statement containing the particulars of the debt sought to be set off. Therefore, an opportunity is given to the defendant to see that amounts due to him from the plaintiff is set off against the plaintiff due by him to the plaintiff. This is only in respect of money claims. The set off can be set up only in respect of money claims, and no other claim is permissible by way of set off. Now, as far as counterclaim is concerned, it is not confined to money suits. It can be a money claim, it can be any other claim to which the party is entitled to, and that he can enforce. A counterclaim is nothing but a claim by the defendant against the plaintiff. It is a separate suit. Instead of filing a separate suit, the law provides for filing a counterclaim in the written statement itself. And the written statement, to the extent of counterclaim, is treated as a plain. And of course, the requisite court fee is to be paid on the counterclaim. And once a counterclaim is filed, the plaintiff gets a right to file a written statement, and issues are framed. Joint trial takes place. If the plaintiff makes out his case, a decree will be passed in his favor. If the defendant makes out a case, again, a decree will be passed in favor of the defendant. There is nothing like a set off. There will be two independent decrees, one in favor of the plaintiff, one in favor of the defendant. There is nothing like setting off one claim against the other. That is set off. Therefore, the same law regarding limitation also applies, and such a counterclaim, unless it results in complications, the court is bound to entertain it and decide it. Now, when such a counterclaim is put forward, and in support of the claim, any documents are also put forward, the counterclaim should include all those things. Now, this is broadly the law which you find in the Civil Procedure Code. Now the question is, because the Civil Procedure Code involves elaborate procedure, delay in disposal of cases, now we are advocating arbitration. They say the strict rules of Civil Procedure Code are not applicable in arbitration proceedings. That's precisely what the section says. Therefore, what should be the procedure to be adopted in an arbitration case? It should be simpler. It should not be as complicated as the Civil Procedure Code. But what is the procedure today we are following? Civil Procedure Code is precise, but the procedure followed in the arbitration case is so elaborate. When you fix the schedule, you fix petition is to be filed within that particular date. 4 weeks or 6 weeks, you have to file the written statement, defense, and then you are fixing a time for rejoinder, reply. Where do we get all this? If you want speedy disposal of cases, and the Civil Procedure coming in the way, and Arbitration Act is enacted on the lines of universal model law, now the procedure to be followed in arbitration should be more simpler than the regular suit. It is because of this today we have the Commercial Courts Act, which is amended so that the pleadings in a commercial court should be so specific. Now, as far as subsequent pleadings, if at all it is required, the Civil Procedure Code provides for a remedy. Order 8 through 9 speaks about what is known as subsequent pleadings. No pleading subsequent to the written statement of a defendant other than by way of a defense to set off or counterclaim, shall be presented. There is a specific bar, except by the leave of the court, and upon such terms as the court thinks fit. But the court may, at any time, require a written statement or additional written statement from any of the parties and fix a time of not more than 30 days for presenting the same. If you go strictly by the civil procedure code, if you want to file any additional statement, apart from the written statement which you have filed, you can file it with the leave of the court. It is not rejoinder. It is not reply. Similarly, if the plain text to be amended, it has to be amended by way of an amendment, not by saying something which you have not said in the plain, either rejoinder or reply. Therefore, it is time the legal fraternity looks into these provisions, the object underlining these provisions, and make this procedural law meaningful. Procedural law is one thing. What we are following today, especially in the arbitration side, is totally different. So at any rate, you can't call it as a plea. You cannot decide the case on what has been said in the rejoinder or replies. So therefore, this is an aspect which has to be taken note of if you want the pleadings to be simplified in civil courts, and this allegation of delay in disposal of cases in civil courts because of application civil procedure is to be avoided. Now, though the Civil Procedure Code exhaustively provides for how a pleadings ought to be drafted, it also provides for a contingency where if the pleadings are not drafted in the manner it is to be done under law, what are the consequences? This is where the lawyer should ponder over. Because if you are not clear about this, the pleadings you have put into court may not be of useful to your client. Sometimes it will be fatal. Now take for example Order 7 Rule 11 CPC. What it says is, if a plaint is drafted, number of pages is not the criteria. The length is not the criteria. When the courts reads the plaint, it must disclose a cause of action. What is a cause of action? Cause of action is a bundle of facts which sets out the right of the party, his grievance, and the relief to which he is sought for in the plaint. If the plaint does not disclose this cause of action, what is the effect? The law says, reject the plaint. When a professional drafts a plaint, keeping in mind this substantive law, the procedural law, and other aspects, and still if he is not able to make out a case, that is, he does not disclose the cause of action, see the consequences. The plaint will be rejected. And for the problem is a decree of the court. Similarly, while drafting a plaint, if you do not keep in mind the peculiar jurisdiction, territorial jurisdiction, and then you draft a plaint. Now Order 7 Rule 10 says, return the plaint for presentation to proper court. If such orders are passed, according to me, you can't hold parties liable. It is the draftsman, it is the legal professional who is to be held responsible. Therefore, it's a very serious job, very responsible job. In fact, when you draft a plaint, there are so many enactments which says, prior to filing of the suit, a statutory notice is a must. Not only a statutory notice must be issued, there must be an averment in the plaint that such a statutory notice has been issued. And if that is missing, again the plaint is liable to be dismissed for non-compliance of statutory provisions. For example, take 80, Section 80 of the Civil Procedure Code, when a suit is to be filed against a government, a notice is a must, and there must be an averment, such a notice has been issued, and 60 days have elapsed, then only the suit is filed. You take many of these acts like Municipal Corporation Act, Municipalities Act, Cooperative Societies Act, where all cases a statutory notice is a must. Not only you must issue a notice, the plaint, the pleading should refer to a notice having been issued. If such a thing is not there, then the plaint is defective and the suit is liable to be dismissed. Now, another aspect to be kept in mind is, today we find in the pleading, so-called plea, evidence, statutory provisions are extracted, judgments of the courts are extracted. Sometimes arguments are also put in the plea or in the defense stage. It may look attractive when you read it, but it is not in accordance with law. If you want to refer to a document, please by all means refer to a document, but not extracting the contents. For example, there is an agreement of sale. You have to refer to that in the plaint. The plaintiff has entered into an agreement of sale, dated so and so, for purchase of the property, for a consideration of so and so. But it is not necessary to say thereafter extract those clauses. That is a part of the document. When something is reduced into writing, the law declares you cannot give oral evidence. If you can't give oral evidence, you can also not plead in the plaint. You have to produce the document. The document, when read, we get to know the terms and conditions. Therefore, this law also says, if you are referring to a document, the effect of the document should be stated in your own words, but not the contents of the document. Similarly, when you are relying on some presumption, don't extract the section itself. A word should be sufficient. At any rate, when you are drafting the plaint, that should be kept in mind so that the other side knows what you are saying. So therefore, though specifically the civil procedure court say the plaint should not contain evidence, when you are pleading, you must know what is the evidence which is to be adduced in the case. And before you adduce evidence, there must be a plea. And the pleading should be confined to raising that particular plea, and leading evidence is a subsequent act, and then comes the question of proof. So if the pleading contains everything all in one, pleading, evidence, arguments, contents of the documents, statutory provisions, and the arguments also, and also the statutory judgments, with great respect I say, it does not reflect a good draftsmanship, because drafting is an art. Drafting is an art. Every word should be weighed. You must know the meaning of what you are saying. You must know the substantive law behind that particular plea. You must also know what is the evidence to be adduced, and then a pleading is to be drafted. So mere command over English language, using very big words, is not a substitute for a good legal pleading as required under law. And if the draftsman, the lawyer, does not keep in mind all these aspects and were to draft, and if the client's interest suffers, well, the profession gets a bad name. In the end of the day, the object of the pleading is to tell the opposite party what your case is, to tell the court what your case is, so that at the earliest opportunity, the judge, having understood your case, should be able to give you the relief which you are seeking for. If that ultimate object is not achieved, this exercise of drafting is of no use. Now, coming to the arbitration cases, as I repeat, today there is no end. Pages and pages, volumes and volumes of pleadings are put. Really, I do not know what is the object sought to be achieved. Especially in the arbitration side, the contract itself is, entire thing is extracted, documents are extracted, and the pleadings will be in terms of 2 or 3 volumes. Then we have other 6 volumes of defense, then a reply, then a rejoinder, and then at the time, at the stage of arguments, one small argument, a big argument. See, there's no end to this. I personally feel, because the ultimate object of the pleadings is not kept in mind. The interest of the kept in mind is happening. It is not the number of pages. It is not the way you are expressing yourself. It has to be within the 4 corners of law. The object is to be achieved. and that is not possible. Well, as I said, pleading is the foundation of a case. If the foundation is not all right, if the foundation gets complicated, case also will get complicated. Simple matters are made complex, and therefore it results in delay of disposal of cases. So my suggestion to the legal practitioners is, please take these statutory provisions with all seriousness, put it into practice, make these pleadings simple but effective so that quality justice could be administered in courts. By confusing the judge, by confusing the opposite party, complicating the issue, you are not advancing the cause of justice. Justice is a very wonderful concept. Injustice is done and justice is to be done. It is possible only when the parties understand what the claim is, what the injustice is done, and then what is to be done. So if that object is not achieved by the pleadings, then it is not worthy. At any rate, when I say it is an art, advocacy is an art, drafting a good pleading is an art, and one should be proud of such pleading. Thank you. I will have some questions.
Yes, sir. In fact, I also get myself muted so that there's no disturbance from our side. This is by Divya. For non-compliance of Section 80 CPC, application are filed citing urgency, in view of which notice not filed. If such an application is filed, does the plaint still become defective?
Plaint will not become defective. On the day you file the plaint, it is perfectly all right. Suppose the judge says the urgency which you have pleaded is not there. Then you have to take back the plaint, issue notice, wait for the 2 months, and then come back to the court. Filing a suit without issuing notice is defective. But there is a amended provision which provides for an application for disbursement notice. You have filed the application, therefore it is perfectly valid. But if the court says no, then you have to get back and issue a notice. Then after 60 days, you have to come back to the court.
This is by Ayushi Mishra. For suits related to monetary claims, how should one decide it? She should file a set-off or a counterclaim?
I said, first of all, the set-off is purely money. Now, if this amount set-off is in excess of the amount claimed, that excess amount becomes counterclaim. If the amount set-off is within that claim, it would be set-off. That is the difference between a set-off and a counterclaim, firstly. Secondly, the set-off is only regarding monetary claim, as far as counterclaim may be monetary plus other things also.
Yeah. Anubhava Srivastav, can the respondent in the divorce case request the court to put the pleadings in a sealed cover or not allow any third party to file for to apply for a certified copy?
Is it after the case or before trial?
She hasn't posted that. She will post it. Meanwhile, we can take, if the strict rules of CPC is not applicable to arbitration, why can't a simpler procedure be applicable to courts as well?
That's precisely what I am saying. Law is very simple. We lawyers have made it complicated. First, we must obey the law. Now, see the amendment to the Commercial Courts Act, that will give you an idea. Now, very strict rules are made, and there is a claim for more than 1 crore. If for a more than 1 crore, the strict rule is to be applied, according to me, it should be applied to small cases also. And it should be equally applicable to arbitration cases, because most of the arbitration cases fall within the definition of commercial disputes.
And this is by Shrikant. No, Shrikanteshwar. Can the registry transfer a partition suit having substantial monetary implications and the issue of probate of a will to be tried by commercial courts?
It doesn't fall under the commercial courts. Probate proceedings are to be before the district court, designated court. Commercial courts will have no jurisdiction.
Anubhava has clarified. She says that the petitioner is withdrawing the case and the written statement is already filed. In the case where she was saying, the question was whether can a respondent in a divorce case request the court to put the pleadings in a sealed cover or not allow any third party to file to apply for a certified copy.
It can be done. It can be done. Normally, the matrimonial matters, certified copies will not be given to any person other than the party to the proceedings. If any other person wants a certified copy, he has to file an affidavit, make out a case. Normally, it is not given.
Okay. This is by Murtaza. When a plaint is dismissed due to non-compliance of any order, then what is the further course?
You have to make an application for restoration by complying with that. For example, non-payment of process fee. Now, plaint can be rejected. You have to pay process fee. You are not. You did not appear on the day when the case is called dismissed. You have to file an application for restoration. You cannot file a fresh suit.
This is pleadings maybe by a legally trained person or a person who is not trained in law. How does the court deal with the pleadings of a person who is not legally trained? Can we say that the court has the responsibility to help guide the pleading of a person not legally trained?
Certainly, ultimately, the court has to do justice. If the lawyer is not the person who has prepared the pleading, party himself has done it, he will do it to the best of his ability. And the court certainly will have a broader outlook. It may not be very technical in that. But at the same time, whether the party has filed the pleading or the advocate has filed the pleading, it must disclose a cause of action. Otherwise, what will the judge do? It must show what is your right, what is the infringement, and what is that you want. If these things are missing, the court can do nothing. It need not be artistic. It need not be so legal as a lawyer does. But whatever you say should convey to the court that you have a right and that right has been infringed, and therefore there is a cause of action for you to come to court, then only the court can grant the relief.
This is whether new plea can be taken at an appellate stage. However, Section 99 says appellate court cannot pass judgment at variance on account of mistake, commissions, defects, or error at the trial court.
That's what I said. Now, amendment of pleadings has been made very, very strict. Earlier, before amendment, an applicant amendment could have been filed in the appellate court, in the second appellate court also. Now it has been very clear, all applicant amendments should be filed before commencement of the trial. If once the trial commences, as a rule, amendment applications are allowed. But amendment application is allowed if the party is able to show, but in spite of due diligence, he was not able to plead that particular fact. And depending upon the facts of the case, court may permit it. Normally, with that amendment, today amendments are not permitted at the appellate stage. But in a given case, if the court feels to do justice to the parties, that amendment is required, court is not powerless. Court can grant it.
This is by St. Claus. In a will case, the defendant is not proving the will by the testatus. But after 10 years, he brings one of the defendants as witness to prove the will. What would be the fate?
No, if the defendant has not proved the will and the suit is dismissed, the question of his bringing another witness afterwards will not arise. The witness to be examined in proof of will should be done before the case is decided. It cannot be done in installments. Today it is dismissed on the ground that he did not bring a witness. Afterwards he cannot bring the witness. That is not permissible in law.
Yeah. There are no more questions. I'll just apprise the next two webinars with your good self. Yes. Thank you to all the participants for participating in the webinar, for having the deeper dive into the aspects which Justice N. Kumar, as usual, has clarified in a very elucidate manner. And keeping in view his immense knowledge, he has agreed for 2 more sessions. One is on the 2 parts: examination of witnesses, civil trial, and the Arbitration Act. One would be on 13th of December 2020, and one is on 14th of December 2020. So do connect it for those webinars. These are in continuum of this today's session. And tomorrow at 4:30 p.m., we would be having Mr. Suryanarayana Rao, who has also been giving his insights on this platform, and he himself is also running a webinar series down in Madurai. So everyone stay blessed, stay safe, and sir, we are all thankful the way you have shared your knowledge and time on this platform. Thank you, sir, and thank you to all those participants who have been watching us live on the Facebook, YouTube, and on this platform. Thank you.